So we're living in some very serious times right now. Our civil rights are in jeopardy. Our voting rights are in jeopardy. There is a very important case pending before the U.S. Supreme Court right now, and that's the case of Louisiana versus Callais. And I'm going to take out time to talk about that case, talk about the significance of the case, and share my thoughts about the oral arguments made in the case. Welcome to New Possibilities. I speak truth to power without fear. So Louisiana redrew their congressional districts. So after the census, they created 6 legislative districts, and 5 of those legislative districts were majority non-black districts, and only 1 was a majority black district. And so plaintiffs brought a lawsuit. And before I get into the lawsuit, it's very important to point out that black people make up 30% of Louisiana's population, according to the census. That's nearly a third of the population in Louisiana, even though the maps were set up to only give black people 1 district. So plaintiffs went to court, and the court found that Louisiana's redistricting maps violated Section 2 of the Voting Rights Act. And because of that violation, the court ordered Louisiana to redraw the maps so that there would be 2 black congressional districts. And so after that, a group of plaintiffs, another group of plaintiffs, non-black plaintiffs, brought a lawsuit basically challenging the creation of those 2 black districts. They basically said that that was a violation of the Constitution, in particular the 14th Amendment. And they also questioned or challenged the constitutionality. When you boil it down to its final analysis, they questioned the constitutionality of the implementation of Section 2 of the Voting Rights Act. Now, I'm going to provide more information. So just so that you understand what Section 2 of the Voting Rights Act is, it is the section of the Voting Rights Act that prevents jurisdictions from discriminating against voters based on the color of their skin or based on their race. It also prevents jurisdictions from diluting the vote of African Americans and other minorities. And so that particular section is being challenged in this case of Louisiana versus Callais. And in order to understand what vote dilution is, I will provide you with 2 basic examples. You have what's called packing, for instance, where the black population is concentrated and packed into one particular district, thereby diluting their vote. So instead of being able to elect candidates of their choice in multiple districts, their population is packed into 1 district so they can only elect 1 candidate in 1 district. So that's the first example. The second example is called cracking, where a black population is broken up and dispersed into predominantly white districts in such a way that they are unable to elect the candidate of their choice. So instead of being able to elect, for instance, the candidate in a 1 packed district, they are unable to elect the candidate of choice, period. So their vote is diluted. And voting is not just something so that you could go to a poll and say, hey, I voted. If your vote is diluted, that's virtually the same as depriving you of the very real right to vote. And that's what vote dilution does. So once the court entered the order requiring the creation of those 2 black congressional districts, you had this group of non-black voters challenge that. And so that is what's pending before the court now. And I listened to the oral arguments. And as I listened to the oral arguments, I was very disturbed by the fact that you have these attorneys using civil rights language to undermine civil rights. They are weaponizing color blindness against black progress. They are weaponizing color blindness in order to take away power from black people, to diminish our vote, to dilute our vote. That's what they are trying to do. They are crying, whining and crying about what they have labeled as stereotyping, when this case has absolutely nothing to do with stereotyping. They're making it seem like they're so concerned about the stereotyping of black voters when that's really not what they're concerned about. They're concerned about black people obtaining political power, and they're trying to do everything that they can to undermine black political power. And they're trying to do so by pretending that they're concerned about stereotyping of black voters when they couldn't give a damn about stereotyping of black voters. They're pretending like they're concerned about the stereotyping of black voters when that's a non-issue, because here we have a situation where there are experts that have done comprehensive studies that prove that there is a problem of racial bloc voting in Louisiana, where black voters' rights are being undermined. Their vote is being diluted because it's a situation where you have white bloc voting that is set up in such a way that it is used to constantly undermine black people's ability to elect the candidates of their choice. You have a situation where these people are basically expecting people to address a problem involving racial gerrymandering without considering race, and that's virtually impossible. You can't fight racism without considering race, without seeing the role that race plays. You can't fight a map that is racially gerrymandered to dilute black voters without creating a remedy that considers race. But that's what they expect people to do. And the fact of the matter is, as the attorney from LDF pointed out, the lead attorney from LDF pointed out, if these people have their way in this case, this will have a horrible impact on the black community. In states where they depend on these remedial maps to address the problem of vote dilution, and these remedial maps have made it possible for black elected officials to be in office, that will fundamentally change. There will be fewer black elected officials in the South. Fewer black elected officials. And that means that black people will have less of a voice in Congress. Less of a voice. And the other thing is this: it won't only impact the South, it will be open season on black voting rights. They will be able to racially gerrymander around the country, making it possible that we will lose many black seats in Congress and many black seats in other aspects of the government, thereby diluting the black vote, the black voice, and black power. We will no longer have a seat at the table. Instead of having a seat at the table, we will be on the menu. And all the issues that our ancestors and elders fought and died for, all the progress they fought and died for, will be reversed in a matter of time. So we won't have a voice on issues involving education. We won't have a voice on issues involving healthcare. We won't have a voice on issues involving criminal justice or the environment or housing. We will see a complete reversal of the progress that we have made in this country, just like we saw a reversal of black progress during the end of Reconstruction. These are very serious times. Very serious things are at stake right now. You know, and the thing that's so disturbing, another thing that's so disturbing about this case is the fact that there is so much legal precedence that is in jeopardy. Legal precedent supporting Section 2 of the Voting Rights Act, supporting the Jingles case, which outlines the formula for bringing a Section 2 complaint. All of that is in jeopardy at the whim of these attorneys and these Supreme Court justices. And as I listened to these arguments, I just thought about like how political the U.S. Supreme Court is. Because if this was a legitimate court of law, there is no way in hell that that case would even be able to go to the Supreme Court in light of all the precedents against what they're trying to argue in this case. So much precedent. You got a case that they recently decided, Allen versus Milligan, which addressed all these points that are being raised by these attorneys. And the sad thing is they're using this case of Students for Fair Admissions versus Harvard. That's that anti-affirmative action case. They're using that as a justification to tear down all the progress that Black people have made. The Trump administration has been using it to undermine diversity, equity, and inclusion. And now they're trying to use that case to undermine our voting rights. And the thing is, as counsel from LDF pointed out, that case was decided around the same time as Allen versus Milligan. So that case played no role in Allen versus Milligan, and it shouldn't play a role now. But the mere fact that they are considering this case shows you the political nature of the Supreme Court. It shows you that it just shows you the nature of the court, and it shows you just how important these elections are, just how important they are, because the president appoints these people to the Supreme Court. So this should be a wake-up call to show us just how important the vote is. If our vote wasn't important, they wouldn't be doing everything in their power to undermine our vote. It's time for us to wake the hell up. These are serious times, and I hope and I pray that LDF is successful in this case. Otherwise, we may see an end to the voting protections that we have relied on for so long. The Voting Rights Act has already been substantially gutted by, when they gutted Section 4 and 5 of the Voting Rights Act. And now they're going after Section 2. Nothing will be left to protect our right to vote. So with that, I'm going to say, please rate, comment, subscribe, like the video, share the video, and tell me what you think about this. Peace.